Good morning. We'd like to offer a very warm welcome to our attendees across Canada. As we notice people starting to file into the program, I'd just like to take a moment to extend a very warm gratitude as well for the support and for the amount of calls and emails that we've been receiving, dealing with some issues that are pertinent and certainly critical to the survival of companies during the difficult and challenging times in which we're involved. One of the requests that came from some of you attendees, and of course there's lawyers, accountants, and some business owners that have been regularly attending. Many of the comments were along the line that we'd like to have commentaries done in a way that the information isn't an overload. So because we're all tax and finance geeks on our side, it's very easy for us to get into a territory that may not be familiar with a lot of the accountants and lawyers that are on the program. So what we've done is we've broken down our segments into 1 hour programs rather than the traditional 2 or 3 hour programs over the years. And we believe that this is something that is of value. So today's program is part 2 of an ongoing series that deals with estate planning. Today, we're going to be talking about asset protection. And I'd like to just take a brief moment and introduce some of my highly esteemed colleagues that are on the line with us today. First of all, I have Michael Miller, who's a partner in quantum business law. Michael has 46 years of experience in litigation and is no stranger to the territory in Canada with respect to the application of the Fraudulent Conveyances Act or other situations that can have the result of assets being lost because of failure to protect them. I'd like to introduce Lorne Saltman. Lorne Saltman is known internationally as well as across Canada for as a leading tax lawyer, educator, and author. Lorne is currently the head of Gardiner Roberts, and he also acts in the capacity of counsel to quantum business law. I'd like to introduce John McLeod, who appears to be from Barbados, and yet I think he's sort of stranded in Canada right now. Is that right, John?
That's right.
So John is the chairman of Eticas International, which is a group of trust companies and financial institutions located everywhere from Geneva, Switzerland to Singapore to Barbados. And essentially, John is here to add additional insight to many of you who are concerned about losing assets. So again, thank you for joining us. Amongst the various different subjects that we'd like to talk about today when we're thinking of asset protection is how do we order our affairs in a fashion that allows us to be able to not only have protection, but also can result in tax efficiencies. And this is one of the things that we are hearing and seeing on a scale that's disconcerting. We're worried about the fact that in recent times, planning has been done, and more than recent times, I'm going to say over the last several decades, that in some cases is now being attacked. At a recent Canadian Tax Foundation conference, Canada Revenue Agency had mentioned in their formal statement that they would be looking at targeting companies who are involved in certain types of structures, namely structures that are designed to avoid tax by setting up non-Canadian controlled parents or otherwise continuances to other countries. And we believe that this is a major concern. Many of you accountants and lawyers have already got clients now who are facing this. We're also going to be talking about various different methods of creating structures in a way so that you can improve upon what you have now. We look at, what is the problem? We look at tax planning in a holistic sense. So that's why we have a litigator, we have a tax lawyer, we have an individual here who's known internationally in the trust area. One of the comments we have is we really don't understand what trusts are and what trusts are intended to do. So we're going to be focusing a lot on how we can create protection in that way. It seems as though we're having some kind of a challenge here. Is there any sound coming through that microphone, Jeremy? Okay, so we'll continue then without any more delay. So what I'd like to do then at this point is we'd like to just share a couple of diagrams with you so that the things that we're saying can be easily understood. The expression that a picture is worth 1,000 words certainly, I think, resonates with all of us. So here is a fairly common structure that we're seeing across Canada, situation where we have an operating company where a holding company has been created that holds the shares of the active business in this particular case. And essentially, we often ask questions when we do presentations, how many of you lawyers and accountants are working on advanced asset protection and tax planning? And one of the most common answers we get is, this is the structure we recommend. And we say, what else do you do? Sometimes we hear, what else is there? So we're going to be talking about what else is there. So for the time being, it's safe to say that many of you in attendance today, whether you're a business owner or an advisor such as a lawyer or accountant, have been involved in planning that allows you to be able to pay dividends tax-free from an operating company up to a holding company. And the shares of the holding company are held by an individual. And then, of course, we see situations often where in order to create asset protection, well, we set up another company. And on the left, we may have another business, and possibly it holds real estate. Possibly it's just a real estate company. And we loan money from one company to another, believing that we've created asset protection. So what I'd like to do is maybe start this conversation by inviting some of our panelists to comment upon the question that's posed at the top of the diagram. Are the assets in the holdco safe? First of all, I'd like to call on Lorne Saltman to comment on the safety of assets that are sitting within the holding company, or perhaps on the side company, which might be a company that simply holds real estate, where a loan has been given by the opco to the real estate company. Please, Lorne.
There are then really two angles, Todd, that I think we need to consider. One is from the civil law perspective, and then the other is from the income tax perspective. Under the civil law, you mentioned early on the statute called the Fraudulent Conveyances Act, which is found right across Canada and has a lot of historical weight, but not everybody's familiar with the scope of that statute. And I won't go into all the details now. I think Michael Miller will go into more later, but just at a very high level, if a debtor transfers assets to a non-arm's length party, and the purpose is to hinder, delay, or defraud in a civil, not a criminal sense, a creditor, that creditor can sue under that statute, and a court can set aside the transfer. In this context, a transfer by way of a dividend from opco to holdco could potentially be viewed as a fraudulent conveyance. That's one risk. The second is, under the Income Tax Act, Section 160 is an enforcement provision, which provides that if the operating company owes unpaid taxes to the government and pays a dividend, under that section, the CRA can follow the money and assess the holding company for the tax owing by the operating company and in effect, take the assets that have not been properly protected from the holding company. And then just very briefly, Todd has shown that there's a loan owing to the operating company on the right from the operating company on the left. Well, that asset of the operating company on the right is potentially subject to the same liabilities that I've talked about in terms of the Fraudulent Conveyances Act and so on. And so part of the exercise that we're going to be talking about today is, first of all, identifying where the risks are and then coming up with solutions that are driven by asset protection that could have positive tax consequences, but are not primarily driven by tax, which we can get into later.
Well, that's great, Lorne. So I'd just like for everyone in attendance to take a step back from what's been said, because Lorne is focused on three very critical areas that are most often overlooked. Oftentimes when we pay dividends from an operating company to a holding company, the attitude is, well, it's safe, we don't have to worry about creditors. Well, the Fraudulent Conveyances Act to which Lorne referred can be utilized where a creditor, after it's able to be successful at seeking a legal remedy, say a lawsuit against a corporation, say the operating company is sued. Well, if the money's been moved, essentially the wording in the Fraudulent Conveyances Act is very, very broad. It states that if you're attempting to hinder, to delay, or defraud a creditor, then the concern is that the court has the power to make that type of reward. For those of you that are listening to Lorne's comments about taxes, well, it's not uncommon for companies who run a very tight ship to suddenly get hit with a massive tax assessment. And of course, after COVID-19, the government of Canada is going to be facing a very serious, and it already is, deficit. The threat is that CRA will logically be looking for ways in order to catch companies that could be, in some ways, acting in a way that's out of sync with the legislation. Later, we're going to be talking about another subject, and that would be a subject that deals with general anti-avoidance rules, which also you'll hear about later, and is another reason that the CRA can, in some cases, take action. We've had companies where we had 160 contractors who, out of the blue, were characterized as de facto employees, having the effect of a massive assessment against an otherwise very compliant company. And no one ever advised them, nor did they even understand the implication that was going to befall them. And the result is devastating. So one of the things that we caution you about is not to be lulled into a false sense of security. Some companies that will say, well, we've never been sued, or what possibly could we be sued for that our insurance doesn't cover? To that end, I'd like to call on Michael Miller. Michael, what would you say to a company that has the attitude that we've never been sued and we have liability insurance? Do you think that that's sufficient in order to cover any potential claims against the company?
Well, the first thing I'd ask them is to see the policy, because chances are it hasn't been changed for years. And I'm not sure that most business owners or their advisors are fully aware of the actual contents of the insurance policy. And to rely on that means I'm relying on it. So if I am sued, I have a good defense. Well, no one wants to be sued in the first place. So it's not an advantage. And the policy has been changed. The policies have been amended since COVID. So there's a lot of things that you might think you're insured for that you may not be.
And what happens if a company is sued for an amount in excess of the liability limit of the policy? Say the liability limit is 5 million and they're sued for, say, 10 million. What happens then?
Their personal assets be above the $5 million that the insurance is picking up are at risk, significant risks.
We hope that's a wake-up call to everyone in attendance who may have heard themselves or one of your clients saying that in the past. Michael, Lorne had talked about the Fraudulent Conveyances Act, and we talked about the wording being very broad and where the application can be such that there is nothing dishonest required in order for a court to pierce this corporate veil. What can you tell us about some of the case law that exists with reference to the Fraudulent Conveyances Act, and what is the farther reaching threat against some companies and entrepreneurs?
Okay. Those who attend these webinars often or always will have heard Todd talk about the McGuire and the Ottawa Wine Vaults Company litigation. This took place, I'll sort of tell you the story about it, but it took place with a decision in 1913, so about 108 years ago, and it stands for the case law today. So it starts in 1908, where the McGuire brothers purchased a hotel in Ottawa, and the hotel that would have been in 1908 wouldn't have been a Four Seasons. It would have been the type of hotel where there was a bar, probably two bars, one for women, one for men, and a lot of drinking going on. And the purpose of the hotel was when you got really drunk, they'd take you upstairs and put you in the bedroom and charge you for the pleasure of being there. They bought this hotel, and for those in the Ottawa region, it was on the corner of Bank and Sparks Street, which is a very busy location, and they faced Bank Street. They bought it for the large amount of $8,000. They put $6,000 up front, and shortly thereafter they paid the balance, and so the full $8,000 was paid over the next few months. And once it was paid, there were no other debts of the hotel business or of the brothers. But a few months after having made the final payment, one of the brothers transferred ownership and a part ownership in another hotel in Madoc to his wife. And she assumed the ownership and assumed carrying a mortgage. And at that time, the company was very solvent. They were making a lot of money, and things were good. And what often happens once that takes place and you're feeling comfortable, in this case, the licensing commissioner of Ottawa ordered that they take the tavern part of the hotel and put it in the back end so it wasn't visible from the street. Obviously, they were very unhappy about this, the brothers, but they did the best they could. They made alterations to the hotel for $4,000, but business fell off because they weren't right on this corner and they weren't in full sight, and less people were drinking and less people were falling asleep and being taken up to bedrooms. And then they had a small fire. The result of all this misfortune was that 2 years later, in 2010, they went out of business. And a couple of suppliers, Ottawa Wine Vault being one of them, found out that McGuire had no money other than this hotel, and that in fact he had another asset that was worth money that he had transferred to his wife 2 years earlier. So they sued, and they sued saying that was a fraudulent conveyance. You owe us money. You transferred the property out, and we want the money back. And traditionally, at the time, we weren't thinking about future creditors, which we now are, mostly because of this case, which has survived tests over 100 years. So they went to court, and the first court they went to agreed with Ottawa Wine Vault and said, yeah, you know, they encumbered the property and by transferring it to his wife, and that's not good, so give it back. They could take it back to the creditors. This then went to the divisional court, who said, no, they allowed the conveyance. They thought there was good reason to do it. And typically, as lawyers are able to do, they then went to the Court of Appeal, who then set aside the conveyance and agreed with the original court. And then lastly, they went to the Supreme Court of Canada. You can imagine what the legal fees would have been for everyone in that file. Mind you, legal fees probably about $10 an hour at the time. So even though at the time of conveyance, there was no debt, that wasn't enough to satisfy some of the different levels of court. You can, instead of a fraudulent conveyance, you can make a conveyance if in return you got good value, market price value for it, because then that means if you sold it and got money for it, you could follow the trail. But in Ontario, fraudulent conveyances can be set aside. I'm wondering how many of the professionals here and the businessmen, women as well, have put their houses in their spouse's name or their parents' name or their children's name. And they do that for the purpose of avoiding creditors. So when I graduated from law school, after tying up my horse before I went in, I bought a house with my wife and put it in her name because I wanted to be creditor proof. The answer is, based on this case, you're not creditor proof. It doesn't matter who owns the house. If in fact you transferred it for the purpose of hindering or delaying or defraud your creditors, you're out of luck. So you should just check on your home ownership as an example. It's a common error and it should be dealt with, and your client should be advised of it. There's been a recent case that Lorne brought to my attention this week that a fellow did just that. And in court, they asked him, why did you do it? And he said, to avoid creditors. Excuse me. And that was the end of his case, lost. So this is the issue of further creditors, not just past creditors. And whether you contemplated these creditors are there or you're not contemplated of them, if you're not following and watching the Fraudulent Conveyance Act in terms and that sort of thing, you can end up losing. So when we talk about asset protection, putting it somewhere else isn't necessarily, in someone else's name isn't necessarily safe.
Thank you, Michael. I think Michael had mentioned that one of the profound changes in the way that we need to consider asset protection is that not only do you need to be worrying about your your existing creditors, but also your future creditors. So individuals who are unknowingly and confidently moving assets from the operating company to the holding company need to consider their future creditors as well as their existing ones. I'd like to call on John McLeod just for a moment now. John, I would suggest that one other risk to this entrepreneur is he could lose his entire empire without possibly receiving any advice on how he can protect it. And I'd suggest that the way that that could happen is if the entrepreneur was sued personally, then all of his companies could be taken. And I don't know how many of you in attendance are taking measures in order to protect this very basic fact. And it's often that where there is not an evident solution, that's a good enough reason for not taking action. But we're suggesting today we have a solution for that basic problem. And we think it should never exist, but regrettably, it's all too common right across Canada. John, what can be done in order to protect these assets, including shares of corporations, from future creditors, since the whole estate, the whole empire could be taken away with very little notice? What could be done in order to avoid that, John?
Well, that's a really interesting question. And I would say that is the single most important thing that ends up in every single discussion I have with a Canadian client. Whether they're business owners or whether they're people that have sold a business or whether they're inherited wealth or if they're in a high-risk profession, they're all concerned about protecting their assets. And old-fashioned estate planning and the use of trust is probably the simplest, safest, and most predictable way to protect assets. And in this particular case, if you're going to use a trust, which is a concept that's been around since the 12th century, so it's even older than Michael Miller and his compatriots in Ottawa, those structures are highly predictable, and there are other jurisdictions, other trust jurisdictions around the world that don't contemplate a liability that could arise from a future creditor. There are fraudulent conveyance legislation in almost every jurisdiction that I can think of, but only in Canada and one or two others would the fraudulent conveyance legislation or its equivalent ever contemplate a future creditor. So we want to make sure that when our clients, whether they're business owners or just plain ordinary people with significant assets that want it to go to their children and not somebody else. They go through a process of estate planning. There may or may not be any tax benefit whatsoever. Most importantly, it's about protecting the assets for the benefit of their children and their grandchildren and so on.
Thank you very much, John. So we are here to help unsuspecting business owners, as well as obviously accountants and lawyers to who are to understand that there are really excellent tools that are there that can help to eliminate these kinds of problems. There's just one final thing, and that's point 3 on the slide. And really what we're talking about is this loan. There's an expression in litigation that all assets are exigible, meaning that if an operating company loans funds to, say, a corporation that holds real estate, well, that asset, that loan is on the balance sheet of the operating company. And clearly, it can be attached. Clearly, the loan can be called by a creditor, and we can force payment by another company that possibly owns real estate or other assets that could be liquidated in order to enforce judgment. And we could potentially petition the company into bankruptcy, another company. So the idea of piercing the corporate veil is a real risk for all of the reasons that we've been describing. There's other risks, and we've mentioned the recent Canadian Tax Foundation conference. Certain structures have come under attack, and it's a well-known fact that there's a trade-off between having various different sorts of structures. As an example, a Canadian controlled private corporation is subject to tax at different levels. Tax on active business income and a different tax on passive income, or income that's generated through investments normally, and some other types of income that are referred to as passive income. Again, it just means that it's not active business income. So returns from stock portfolios or mutual funds or interest-bearing vehicles and so on all fall into that category. And we're seeing companies across Canada that have significant assets, sometimes tens of millions of dollars, sometimes more, sometimes less. But nonetheless, these companies often are seeking to pay less tax to avoid paying tax. The concept of GAR, the General Anti-Avoidance Rules, are something that I think we all need to consider in this context. I'm not sure if you recognize this young man, Hugh Grosvenor, 7th Duke of Westminster. He's earned the envious reputation of being the most eligible bachelor in the world. He inherited some $8 billion without paying a penny of tax. Well, that's quite remarkable. The way that he did that, by the way, is his father, who passed away in 2016, left this wealth to this young man. And since the assets were held within a trust, he was the beneficial owner, but not the legal owner. To John's point, this is an example of where proper tax planning can be done. There's certain benefits. Then I'll refer to his great-great-great-grandfather. This is the 2nd Duke of Westminster, who, by his namesake, shares the identical name. So here, Hugh Sr., as it were, is well known for helping to create the law in Canada that governs GAR, or General Anti-Avoidance Rules. This is another individual here. This is the Chief Justice of the Tax Court of Canada, through various different decisions, had applied the various different legal concepts, such as doctrines of substance over form and other things, to give rise to what we have today. What I would share with you is that there was some very profound words that I will paraphrase from the Duke of Westminster, and this is the 2nd Duke. Well, there was a situation where he had a gardener who he was paying, a regular salary, and of course that was to be paid with post-tax or after-tax dollars. In other words, the expenses for the Gardiner was not tax deductible. Well, the Duke's advisors got a little bit clever, and they decided that they would pay the Gardiner by an annual fee rather than a regular salary, but through 52 payments or bi-weekly payments, perhaps. This resulted in the payments becoming tax deductible just by simply changing the mode under which the Gardiner was paid. Well, needless to say, the tax authorities were not amused by this. To quote and to paraphrase Lord Tomlin, who presided over the matter, when an individual orders his affairs in a way that results in the payment of less tax, and that is paraphrasing, his words are far more eloquent than what I'd be capable of repeating, then without regard to whether or not the tax authorities or his fellow man may approve, the individual should not be subject to a higher rate of tax due to his ingenuity. Well, for many of us, that's good news. That's refreshing. And more importantly, this is the backdrop for the general anti-avoidance rules that exist in Canada that we can depend upon with certain nuances. Then, of course, we know that the Chief Justice of the Tax Court of Canada, the Honorable Donald G.H. Bowman, and Lorne and I have, possibly some of you have seen us lecture with Chief Justice Bowman, as he was then called. In various different cases, Chief Justice Bowman had applied the concept of substance over form in a fashion that allowed us to be able to develop case law in Canada that really causes us to be able to confine the definition of what is garble to some very straightforward and advantageous ways of understanding things. Essentially, when we consider substance over form, oftentimes, what is the reality of a transaction? What is the benefit? What are the liabilities, and so on? Well, the reality is that there's many structures that we see being created. And I'll start by talking about this one. And this is a situation that I'll have Lorne explain. Lorne, please.
Sure. As Todd alluded to earlier, when a Canadian-controlled private corporation earns investment income, in Canada, we've adopted the system of what's called integration, so that an individual resident of Canada earning investment income pays the same aggregate amount of tax, whether the income is earned personally or through a vehicle like a holding company. And the mechanism simply is that the holding company has not just the regular amount of tax, but a federal surtax on top of it. So the aggregate corporate tax initially is roughly 50%, about the same thing as the individual would pay if the investment income were held personally. But if the corporation pays a taxable dividend to its Canadian controlling shareholder, it will get a refund of that corporate surtax, and the individual will pay individual tax, but with the benefit of being able to claim the dividend tax credit. So again, the policy would be roughly a 50% tax, whether it's investment income earned personally or through a corporation. Well, recently, some clever people have tried to avoid the corporate surtax in the corporation itself by creating structures that they assert are not Canadian controlled, but controlled by non-residents, and therefore only the regular corporate tax should be applicable. And one of them on the screen here is a Delaware holding company. So what we've seen is a Canadian corporation files, let's say in Ontario, articles of continuance, which means that it would be viewed by the incoming jurisdiction of Delaware, once it's continued there, not as an Ontario corporation anymore, but as a Delaware corporation. And so the argument is put forward that it's changed its jurisdiction to be non-Canadian, but it's still a private corporation under the Income Tax Act. And the attempt being made is to argue that that corporation is subject to tax only at regular federal rates, not the surtax. As Todd mentioned earlier, the CRA is attacking these, and some of the accountants in the audience today may know about some of their own clients who are being faced with a reassessment in which the CRA is challenging the Delaware company and saying that the general anti-avoidance rule applies because, first of all, the company was set up for a tax benefit, not paying the federal surtax. Secondly, the purpose for setting up continuing the Ontario company into Delaware is purely to achieve a tax benefit. There's no non-tax benefit such as a proper business purpose to doing so. And thirdly, based on how I've described the underlying policy of integration, when the real control of the Delaware company still resides with the Canadian entrepreneurs, this structure defeats the very purpose for which our integration system was set up. And so it's an abuse of the provisions of the Income Tax Act and ought to be set aside. So that is an example of where there's a serious risk of existing structures where there was a continuation. Just very quickly and briefly, a second structure has been used as well, which is just setting up a regular corporation in the United States, a so-called C corporation, which is similar to an Ontario normal corporation. And the ownership of the Canadian shares is placed in that C Corp in the United States, the shareholders of which are the Canadians. So the argument is that the control has been changed to a non-resident corporation, but the CRA is looking through that and saying that the C Corp is an abuse in the same way as I've described the earlier continuance arrangement. So both are being attacked under GAR, and both are quite vulnerable to successful attacks.
Well, thank you very much, Lorne. I don't know if anyone in attendance are fishermen, but if you've ever fished in the deep south, perhaps you've run into the alligator gar. Pardon the play on words, but the gar is considered a ferocious predator of other fish, not of people, fortunately. It can grow to 8 or 10 feet long. And you can see by the picture here, you wouldn't want to be bit by one of these. But if you look at this, we can see one fish in the gar's mouth, and the other fish is quite pleasantly enjoying the serene beauty of the waterway without a lot of concern. So in effect, what we're really trying to say to you is that respect for the law creates a certain burden on all of us advisors. And that is that we have an obligation to bring to the attention of our clients matters of risk. And if we don't want to wait until CRA comes knocking at your door or the door of one of you business owners who have set up a structure which offends the concept for which GAR is intended to remedy. The fact is there's a few very simple and straightforward issues that have come out of GAR. And I mentioned previously that some of the cases of Chief Justice Bowman have been instrumental in assisting and making sure that the law in Canada can be applied. Chief Justice Bowman understood the law with respect to GAR. He understood the substance over form concept, and he very accurately applied the law. At times, he may have bent or stretched the law, or perhaps he created some new law. Having said that, we have a climate today where an individual is seeking a tax advantage, as per point one, where there is no purpose other than tax avoidance, and where there's a misuse or abuse of the legislation that can result in you being the wrong fish. Let's talk a little bit about this. Let's step back for a moment. In the structure that Lorne described, there's no question that there's a benefit in tax. If you have an investment portfolio inside of a corporation, you're paying tax at over 50%, regardless of which province that you happen to reside in Canada. If you had have undertaken to create a structure using a Delaware Corp or a BVI, British Virgin Islands Corporation, to hold shares of a company back here in Canada in an artificial way, then first of all, that's a misuse or abuse of the legislation. The fact is that most of these companies have no clients in BVI or in Delaware. They have no employees there. The only reason for doing it is to avoid paying tax. The second thing is that it's lacking a purpose. But the good news is there are structures that are available that do not require us to put clients at risk, or for you business owners who may be in attendance, to allow your interest to be at risk of such a very serious threat. So first of all, the tax advantage is clear, the misuse is clear, and Canada Trust Co. Essentially set the standard with these three questions. Is there an advantage? Was there a purpose other than tax avoidance? And was there a misuse of the legislation? Those are the three things you have to ask yourself. And candidly, we've helped to defend taxpayers, both the CRA and the tax court, and it would be an uphill battle to defend any of these very, very popular structures that exist right across Canada, in our view. Having said that, we'd like to change the optics of this whole thing, change the direction. And Lorne was talking about trust, John was talking about trust previously, the fact that they've been in existence for a very long time. And essentially, we find that mostly they're enshrouded in mystery. John, I'd like to maybe just call on you for a minute. And the reason I'm doing this is because I'm suggesting that inherent in the concept of trust and in trust law in Commonwealth jurisdictions is a protection. Trusts are often used for the purpose of achieving asset protection. You're going to be hearing over the course of the next 20 minutes or so how you can create a bona fide purpose for a structure that can provide tax efficiencies that are otherwise unavailable, but more importantly, protect your assets in the event that a company is sued and they take the assets from the holding company, in the event that the CRA decides to apply 160 to attach a dividend that was paid from an opco holdco, or in the event that a shareholder is sued and they take his corporation and all of his businesses. So we're going to hear about this right now. And John, maybe you could very briefly help us to understand the overall concept on how business owners can protect their assets through the use of a trust.
Sure. And let me just begin that conversation by reflecting on what you and Lorne have just said. We are involved in our group of trust companies around the world in setting up trusts for Canadians in various jurisdictions. And in every one of those trusts, we have a legal opinion. And unlike the holdco structure that you've described before, and I haven't seen the legal opinions or the tax opinions on those, I guess the opinion would talk about how CRA will treat the structure and the foreign component. In all of the legal opinions that I see from Todd and Lorne and others, there's no real mention of taxation. It's all around the concept of protecting assets for future generations. It's all about preventing or offsetting the risk of a matrimonial properties claim in the next generation, a claim against your children. It's all about eliminating or reducing estate taxes in foreign countries, maybe where you've got your Florida home or your Barbados home. It's all about minimization or avoidance of probate. And in practice, what happens is that we act as trustees of these trusts. In most cases, in the Canadian cases, it's deemed to be a Canadian trust, notwithstanding we may administer it in Barbados or Switzerland or somewhere else. It's deemed to be a Canadian trust, and we would go to the client's accountant, provide them with the financial information, the dividends, the interest, the gains, the losses, and whatever else, and say to that accountant, go file this tax return for this trust. And if I suspect if CRA ever did a deep dive into this, they would find that the purpose of this trust is exclusively the intergenerational transfer of assets. Now, back to the original question that Todd posed, which is, what are and Jeremy, if you could go back to the previous page, that'd be helpful, thank you. Who are the parties to a trust? Very, very quickly, there's the settlor, who is the person that creates the trust. There is the trustee, who in our case is a global trustee company, can be us, if it's a foreign trustee that's required. The beneficiaries are the family members or charities or related parties that wealthy people, whether they're business owners or not, want to provide for. The protectors are the individual or the committee of people who have the ultimate power of being able to remove and replace the trustee regardless of where they are. And finally, the function of the trust is, as I elaborated a minute ago, it's all about intergenerational transfer of assets and looking after children and grandchildren and great-grandchildren and preserving wealth for multiple generations. And as Todd mentioned, this is 900 years old, so hasn't been overturned yet. And so what one looks for is a jurisdiction, and I'll pick Barbados because I'm a resident there. It's 300 years of good trust law and common law and a good court system and favorable decisions and so on. And by the way, it happens to have a bilateral income tax treaty with Canada, as well as a whack of other places, unlike many other international trust jurisdictions. So what we do, as you can see in the slide that Jeremy has put up, is very conventional, boring, old-fashioned estate planning. The only difference is the trust isn't an Ontario trust or a British Columbia trust. It's a foreign trust, generally in an asset protection jurisdiction. And who is it that's going to do this slide? Is that Lorne?
I'll just maybe comment on the anatomy, and I'll have Lorne and yourself and Michael comment. So I'll just cover essentially the basic structure, and then I'll have everyone comment on their part. So I'm going to start off by just describing how this works. And up until now, we've described a structure that's under attack. If you have a structure like that, we can repair that. We can create a structure that is everything that your non-CCPC structure is not. In the past sessions, we have spent a lot of time talking about estate freezing. And we've explained that estate freeze is done in order to reduce the tax on death. Since an entrepreneur has to pay tax if he sells his shares, capital gains tax in Canada, and upon his death, then his shares are taxed as his other assets based upon the fair market value that it has grown to. Therefore, an estate freeze is a fundamental purpose for achieving something that's broad in its range of benefits. An estate freeze has the effect of limiting, reducing, or capping the tax liability on death. And in this particular case, an entrepreneur who has shares in a corporation simply exchanges common shares that grow as the value of the company grows with preferred shares which stay the same value. And by doing that, the value that exists today, and particularly in light of COVID-19, may be perceived as much, much lower, which means that he's able to essentially give away all the future growth from today forward to a trust in a foreign jurisdiction. Now, by the way, I'm not describing a situation where we move a company through a continuance or any other method outside of Canada. In this particular case, we would look at various different jurisdictions, depending upon what is best suited for the individual. This application allows us to be able to have a custom tailored solution. And it doesn't apply to everyone. It's not a one size fits all. Some individuals may be appropriate for a US trust, or others for a Barbados trust, others for some other place like Switzerland and so on. One misconception: it doesn't mean that you have to have an extraordinary amount of wealth to do this. You can have what may be a moderate size estate and do an estate freeze, have the new common shares that have a nominal value and voting control issued to a trust. I'm sorry, no voting control.
Right.
Having the result of enjoying all the benefits in the operating company. We would then create a separate company, an investment corporation, and we would have a conduit which would allow us to be able to pay dividends. In other words, shares. In order to pay dividends, you need shares. So we issue shares that have a nominal value to an investment corporation. And we essentially would be paying this dividend tax-free to this corporation. Having said that, what we've done is we have gone outside of Canada, because the Fraudulent Conveyances Act that we've been talking about is one that looks not only, according to case law, at existing creditors, but also future creditors. And who knows who future creditors could be? There's Commonwealth jurisdictions that are very favorable, which reduces the likelihood of having this structure attacked by a creditor. All of these things give rise to a purpose. And as Lorne describes some of the nuances, I would like for you to envision Lorne as being an expert witness at the Tax Court of Canada, where CRA has challenged this, and they've said, Crown Counsel has said to your lawyers and to the court, there's no purpose for what you're doing other than one, and that is to avoid tax. The consequence of this would be, as a natural consequence, that the investment earned through Invesco, rather than being 50%, goes down to only 26.5%, a tremendous reduction in what the tax would have to be. But the question is, when we talk about Chief Justice Bowman and the decisions that he's made over this issue, over the substance over form and these legal arguments. Well, the good news is we have the three criteria. Was there a tax advantage? Sure there is. We have a reduction in tax. Is there an abuse of the legislation? Which here is not artificial. We really do. We really are setting up a structure for very specific purposes. And what are those purposes? So I'd like to turn it over to Lorne to talk about what the purposes are as an expert witness in this make-believe trial that we're hosting.
Okay, so the first point that I would make is there's a distinction between a result and a purpose. If the investment income is taxed at half the normal rate in Invesco, as Todd has described, that's a result. And it's a positive result for taxpayers, and the CRA may view that as a negative result. But that's not the way the Income Tax Act is drawn, particularly the GAR, one has to look not at the result, but what's the purpose? And it's a very important distinction that Parliament enacted when they enacted the general anti-avoidance rule, because the principle from the Duke of Westminster that Todd referred to earlier, permitting Canadians to arrange their affairs to reduce tax, should be respected. Canadians ought to be able to legitimately arrange their affairs so long as it's not abusive. Within that context, I would say that the main driver for this structure that you're looking at in the diagram is asset protection and wealth preservation through the use of a trust in a jurisdiction which gives superior protection than a typical Ontario trust. We've often seen a typical Ontario trust, or this could be in any province, where, let's say in a family context, a husband, wife, and what I call a friendly stranger, three people are the trustees of a domestic trust that can accomplish an estate freeze, but is inferior asset protection because of the issues we've talked about before, Fraudulent Conveyances Act. And so we choose a jurisdiction, an appropriate one to the particular client, and let's consider, for example, Barbados with John McLeod's corporation being the trustee. We choose that jurisdiction to achieve superior asset protection for the family. We are going to structure it in the way that we set out here. In other words, the entrepreneur can continue to have voting control of the operating company through the preferred shares on the far left, fixed value preferred shares, but voting preferred shares. And we want to have the ability to split the increase in value or liquidation entitlement going to our long-term investor, the foreign trust. So we create Class A common shares that don't entitle the holder to dividends, but to liquidation entitlement. And then on the right side, we can create another class of shares, dividends only, with no liquidation entitlement. So in the future, as OPCO earns income that might be surplus to, first of all, its regular needs, but also we've talked about in past webinars, the ability to claim the lifetime capital gains exemption. There are certain tests that have to be met for the shares to be qualified small business corporation shares. One of them is that we have to limit passive assets during the 24 months up to a disposition date to no more than 50%, and at the time of the disposition, no more than 10%. So if we have surplus, we can pay up dividends tax-free on the right side from the operating company to the investment company. And that because that investment company is owned by the foreign trust, controlled through the voting common shares, there is no federal surtax on investment income. That happens to be a natural consequence of the structure. The structure is, the purpose of the structure, again, is asset protection. And the result is a tax benefit, but it is not the main purpose. So in our view, GAR would not be successfully used to challenge this. This would not be viewed as abusive, and arguably it might not even be viewed as an avoidance transaction because the purpose is not primarily tax, the purpose is primarily asset protection. So we think this is a bona fide structure for an estate plan whose primary purpose is asset protection, but can give very significant tax benefits as a natural consequence of the structure.
Thank you very much.
Can I cross-examine for a moment?
Please.
Mr. Saltman, has this plan been tested in the courts?
Not specifically. Not
Okay. And how long has this plan been put into use?
just really for the last few years. It's one that is innovative and that we've come up with.
And the difference between Barbados and BVI, for example, is the asset protection only?
That is the reason for choosing a foreign jurisdiction, but the laws in each country are different. So, for example, in Barbados, there's a limitation period of 3 years. So if we were to set up a trust today, 3 years from now, a Barbados court will not entertain a challenge against that trust. Another jurisdiction, such as the Cayman Islands or BVI, generally has a longer limitation period, such as 5 years. That would be one distinction. But to me, one of the key elements in choosing a jurisdiction is not only the legislation, but also the institutions and professional advisors that we're dealing with, and the ones that we deal with in Barbados, including John McLeod's company and John McLeod, are superior. I've not found the same in other jurisdictions.
All right, thank you. We're going to reserve our judgment.
I would just like to carry out a couple more of those cross-examination questions, if you don't mind, Lorne.
Please
Say
do.
as an example that there was, oh, sorry. My question is that if we're talking about Invesco, we've moved assets to Invesco. How are those assets safer from a claim or a lawsuit than assets in a Canadian-controlled company, Lorne? And where would they have to go in order to get a judgment enforced if there was assets in the investment company?
Well, what we want to look at is the vulnerability of the ultimate ownership, the common shares that control the investment company. And if there were a lawsuit launched, say in Ontario, with a judgment, and it's taken to a Barbados court to say, we want to break the trust and seize the voting common shares that control the investment company, the Barbados court would say, sorry, we only have jurisdiction over Barbados assets, and this Barbados trust owns shares in Canadian companies, so we don't have jurisdiction to enforce the claim, and they would reject it.
If I could just point out that using Barbados as the example, it's a Commonwealth country. So all Commonwealth countries have a reciprocal enforcement under the Enforcement of Foreign Judgments Act. However, any attempt to enforce those rights under the Commonwealth countries' Reciprocal Enforcement Act must go to a Barbados court to get approval to go ahead to enforce that judgment. And as Lorne, you just said, that approval would not be given.
All right. I noticed that we, oh, sorry. Sorry, Michael, go ahead.
No, Lorne, do you agree with that?
Yes,
That
of course.
going to a Barbados court would not help, even though they're a Commonwealth country.
Exactly.
So we've come to our question and answer period, and we have a question from an anonymous attendee, and that is, did you explain how Duke of Westminster 7 avoid tax through the trust? And perhaps we could spend the next few minutes until 1:15 just answering a few questions. So any of you in attendance who would like to table your questions, please feel free, and we'd be happy to answer them. One of the fundamental differences in this structure versus the BVI and Delaware Corporation is there is no bona fide purpose other than tax reduction. Lorne had mentioned through his cross-examination of him that in the event that there was a claim against this corporate, against the entrepreneur, and in the event that the assets were being called were the subject of a lawsuit, well, an individual would have to go to Barbados to have that asset, the judgment enforced. The fact is that there is no Fraudulent Conveyances Act as it exists in Canada, in Barbados. The legislation in Barbados exists, but it doesn't exist in the fashion that they have to worry about future creditors attaching their assets like we do in Canada. Canada has become, in many ways, a creditor-friendly country, a country that puts the interests of the creditors ahead of the interests of the rest of us. That isn't the case everywhere else. There's jurisdictions in the US, such as Wyoming, Nebraska, Alaska, and so on, which also has certain legislation that exists that can help to protect assets in a way that may be superior. The very reason for setting up a trust outside of Canada is not to send money. It's not to send corporations. In fact, there's never a single penny sent to Barbados if it were a Barbados trust, or say it was a trust in another jurisdiction somewhere else in the world. The reason for doing that is the trust to simply act as a controlling and a holding instrument, holding shares to control an underlying asset, giving rise to a level of asset protection that is otherwise unavailable. I don't think we have anyone else like to elaborate on that answer? Lorne, about the question of, so the question maybe you could answer. I don't think I did answer it. The question is, how does the Duke of Westminster concept apply here? Well, how would you answer that, Lorne?
Okay, let's keep in mind that the Duke of Westminster is a principle that has been, the scope of tax planning has been limited by the general anti-avoidance rule, if it applies. And so when we're talking about setting up a trust, the purpose of which is asset protection, our view is that it's not going to be successfully attacked under GAR. It's a legitimate family wealth preservation structure that has a beneficial tax result. And that would conform with the Duke of Westminster principle and be outside the scope of GAR.
I see you have another question, Todd, under chat.
Maybe I'm missing it. If somebody else could pick it up, can you open it, John? Or
The
Jeremy?
question is, am I understanding that OPCO cannot pay a dividend to the foreign trust, but can liquidate to the foreign trust? Is question part one. Part two, if a lawsuit against OPCO is coming, you can liquidate the assets to the family trust, and the family trust can't assign the assets to the winner of the lawsuit, as it does not have jurisdiction over Canadian assets. Is my understanding correct?
Yeah, I'll address those questions then. First of all, OPCO, I explained earlier that the shares issued to the foreign trust only have a liquidation entitlement. So a dividend is not paid to the foreign trust. It's paid from the OPCO to the Investco. And that's the answer to that part. If a lawsuit is coming against the OPCO, liquidating the assets to the foreign trust is not going to be helpful if it's viewed as being in Ontario, an operating company, transferring those assets, the purpose of which is to defeat creditors. So we have to be very careful about that. The way we move assets around within the corporate structure in Canada is always with a view to complying with the Fraudulent Conveyances Act. And when we're really talking about ultimate wealth preservation, it's at the shareholder level, where, as Todd said right at the beginning, if proper planning for an entrepreneur is not done, a lawsuit can be launched against the individual, as in the case of McGuire versus Ottawa Wine Vaults that Michael Miller cited, where the individual's ownership of the tavern, in this case, the individual's ownership of his corporate empire, would be subject to seizure. With a proper estate plan, we limit that and we put future growth in the hands of a family trust for the next generation. That's much of the focus of a proper estate plan and choosing the appropriate jurisdiction to set up the trust. But all of that still has to be we have to take into account the care with which we move assets around in Canada, so we're not subject to challenge here in Ontario within the corporate sphere.
There's a question.
Can I just read one quick quote from the McLeod case that is quite clear in what it says. It's quoting a case from 1882, but it also still stands. That the line of cases is this: that a man is not entitled to go into a hazardous business and immediately before doing so settle all his property voluntarily. This quote: "If I succeed in business, I make a fortune for myself. If I fail, I leave my creditors unpaid. They will bear the loss." So that's what we're trying to avoid by the Fraudulent Conveyances Act.
Another question, we have an individual that has a corporation. He wants to purchase some rental properties in Hawaii. And the question pertains to having the corporation purchase the property. Is the estate protected from paying U.S. death tax by property? And he's mentioning about he not owning the personal property, and how does he structure it, and does he need a trust? I'll kick it off, and I'll start off by saying that one of the things to be cautious of is if this is personal use property, there is risk of the property in the U.S. generating a benefit to the shareholder that can be treated as a dividend income, even if it's not a U.S. corporation, even if it is a Canadian resident. With respect to structuring things properly in a way as to not attracting U.S. estate taxes, trusts are obviously, in answer to the question, do I also need a trust? I would say unequivocally that a trust would be an important part of the planning. The circumstances that this individual is asking is complicated, and the answers are not one or two lines, and there isn't sufficient time to really elaborate fully. Just wondering if Lorne or John may want to comment on the question in this individual.
Sure, I'll briefly say something, and then John, please jump in. So Todd has assumed that there may be personal use property, but if that's not the case, if it's a pure investment property in Hawaii where rental income is earned, then probably a Canadian corporation is a good structure that will protect the Canadian individual from U.S. estate tax, because when the individual dies, the corporation, the Canadian corporation, continues to hold the rental properties. If we want to have proper planning in that Canadian corporation for the next generations, then we ought to do an estate freeze so that the individual has fixed value voting shares. A trust set up in the right jurisdiction has the common shares that in respect of which growth will accrue for the benefit of the next generation. All of the Canadians, whether they are the individual with the shares of the corporation or family members who are beneficiaries of the trust, all of them are protected from U.S. estate tax by that structure. John?
You said what I would have said.
Okay.
Yeah, the estate freeze is one of those things that we in Canada take for granted. In the US, we can't do estate taxes. We can do estate freeze in Canada where there's underlying assets in the US. One of the greatest benefits, in my view, of tax planning with respect to shares of corporations is the fact that we can effectively kick the can down the road one generation. To Lorne's point about doing an estate freeze, it's almost a no-brainer. What we're hearing from accountants and lawyers as well, when do you do the estate freeze? And what happens if, you have a young entrepreneur who has to dispose of the assets in 21 years rather? Is that a problem? Well, there's certainly planning techniques that are available to extend that period. And really, wherever you have an estate that's likely to grow in value, that's of any size or at all, or a business that seems to be thriving, the right time to do an estate freeze is now. Even if you have a young entrepreneur, even if you don't necessarily have a business that's at a mature level, by setting up a corporation from the very beginning with a trust to hold common shares, which would essentially replicate the effect of an estate freeze at a later period, is always good planning. So we generally recommend that. And we also suggest that by way of personal consultation, the consortium, that part of which is here today, can provide solutions that are sophisticated, they're timely. We can take away that risk that GAR presents, and we can certainly help you to provide for the intergenerational transfer of your assets without the need to be concerned about being the wrong fish. We'd like to thank you very much for your attendance today, and we look forward to our next session. This is a series of programs that deal with tax and estate planning, and all of you are welcome to attend and to invite any of your associates to attend on a complimentary basis. Until next time, we'd like to bid you all a very fine day.